Good morning. Today my topic, the Hindu Succession Act. The Hindu Succession Act came into force on 17 June 1956. It brings about comprehensive and radical changes in the law of interstate succession amongst Hindus. It was very much in tune with the changed socio-economic scenario of Hindu society. The long-left need of improving the lots of Hindu females through an effective legislation was fulfilled and their right of inheritance at par with males was fully recognized. A vigorous attempt has been made to bring some reforms of far-reaching consequences in the system of inheritance and succession. The long-felt need of improving the lots of Hindu females through an effective legislation was fulfilled and their right of inheritance at par with males was fully recognized as vigorous attempt. The law relating to property and its succession required complete overhauling, particularly in the context of women's right to property. After passing of Hindu Women's Right to Property Act 1937, the government had set up Rao Committee to suggest reforms also on this aspect of law. The committee, after studying the existence rules of Hindu succession, suggested some revolutionary changes in the system in order to remove inequalities and injustice the women folk amongst Hindus and accordingly recommended for the codification of the law relating to succession. It also suggested for the codification of Hindu law in successive stages. On the basis of the suggestion and recommendations of the Rao Committee, several legislations were adopted by the legislation, the most outstanding of which is Hindu Succession Act 1956, which represents the biggest reformative outlook of modern Indian society. Object: the Hindu Succession Act 1956 has been passed to meet the needs of a progressive society. The old law, despite several innovations brought about in it by state legislations and judicial decisions, did not fulfill the desired ends and remain hardly acceptable to a dynamic Hindu society of contemporary era. Hence, there was a need for a uniform system of law of succession which may be acceptable to all sections of Hindus and be equally enforceable upon them. With this end in view, the Hindu Succession Act 1956 came into existence. It reforms inequities between men and women with respect to right in property, and it's laid down a common list of heirs entitled to succeed on intestacy. The Act has been passed to amend and codify the entire law of succession. The Act lays down a uniform system of inheritance equally applicable to persons governed by the Mitaksha and Dayabhag school, as also those in the southern India who are governed by the Marumakkadayam and Alias Thana and Nambudiri systems of Hindu law. The Act applies to all Hindus, and the term Hindus includes Buddhist, Jain and Sikhs. It has further been extended even to those persons whose parents are Hindu, Buddhist, Jain and Sikh and who are brought up as Hindus. Section 2. The Act does not apply to the property of a person to whom the provisions of the Special Marriage Act 1954 apply. Section 5. Section 4 of the Act gives overriding effect to the provision of the Act. It abrogates all the rules of the law of succession applicable to Hindus, whether by way of any tax. Any other law contained in the central or state legislation shall cease to have effect in so far as it is inconsistent with any of the provisions contained in the Act. The Act has abolished impartial estate and the special mode of its succession. The Act has extensively affected the entire concept of Mitaksha Upasnari, which was governed by the rule of survivorship. In this scheme, female heir did not have any place, and the property devolved only on the male heirs of the Upasnari on the death of a male member under the Act. The rule of survivorship has a limited application. It would apply in those cases where a male member on his death left co-partners only. In case such male member of a Mitaksha co-partner dies intestate, leaving behind a female here mentioned in class first of the schedule, the property of the deceased would devolve not according to the rule of survivorship but according to the provisions of this act, which provides for a specific share to such female heir. Order of succession. The order of succession provided by the act is broadly based on the doctrine of propinquity or nearness of blood, and accordingly time heirs are divided into 4 categories instead of 3, which are as follows: heirs in class first of the schedule, heirs in class second of the schedule, agnates and cognates. The property devolves firstly upon the 12 preferential heirs mentioned in class first of the schedule to the act, and failing such heirs upon the second, third and fourth class of heirs in that order as laid down in section 8 and 9. The outstanding feature of the above division is that the heirs in class first of the schedule inherit the property simultaneously and accordingly to the doctrine of representation in case of predeceased sons or daughter. Another important point to be noted is that class first of the schedule contains that a list of 12 heirs, out of which 8 are females and 4 are males, of which 1 male claims through a female. All of them inherit in equal shares. All the heirs in class second do not succeed simultaneously, but the heirs placed in one entry would be entitled to inherit simultaneously. In the class of third and fourth categories of heirs, that is agnates and cognates, the rules of preference has been adopted in order to determine the priority. The act has abolished Hindu Women's Limited estate and made her absolute owner of the property irrespective of its sources of acquisition. Any property acquired by a Hindu female in any lawful manner whatever soever and possessed by her become her absolute property, and she enjoy absolute power to dispose of it in way she desire. Section 14 of Hindu Succession Act 1956. The Act has also provided uniform order of succession with respect to property of female Hindu. The right of child in womb at the intestate death and subsequently born alive shall relate back to the death of intestate death. Section 20. The Act lays down some general rules of succession inter alia to the effect that heirs related to a male or female intestate by full blood are to be preferred to those related by half blood if the nature of relationship is the same in every other respect. Another rule is that if 2 or more heirs succeed to the property of an intestate, they shall take their share per capita and not per stripe. Such heirs take the property as tenants in common